Good morning, everybody. Welcome to the final START CCR event of the year. This is our second webinar. We are so excited today about the topic we're going to have. And before we get started, just some quick introductions. This is Leslie over at WCASA, the START CCR coordinator.
And this is Deara Parker. I'm the Community Response Coordinator at Abuse, Wisconsin.
Good morning. This is Sarah Kroll. I'm the Homicide Prevention Program Director at End Abuse.
Hello, this is Peter Fiala, Events and Technology Coordinator at WCASA.
So we are so excited this morning to have Robin, Gricel, and Amber from RISE with us today to talk about an issue that is and I think will continue to affect all communities in Wisconsin, legal protections for immigrants and refugee survivors. So I know we're all really excited to learn from them today. And before we pass it over to them to introduce themselves and get us started, Peter was going to go over some basic logistics for the webinar today.
So you'll see on your control panel a questions or chat box. If you have any questions, just type them in there, or if you're suddenly lost sound, I can help you figure that out. Also, we have a little hand raising button if you have questions that way. And that's about it.
And just a quick note that we are recording this, so this will be available later if you want to watch it again or for those who are missing the webinar. So without further ado.
All right. Thanks, everybody, for, logging into your computers today and joining us for this webinar. Today we're going to talk about legal protections for immigrant and refugee survivors. We're going to go specifically through injunctions, family law, and immigration. My name is Robin. I'm an immigration attorney at RISE Law Center, and I'm here with Gricel. Do you want to say what you do?
Yes. Hi, everybody. This is Gricel, and I do family law and protection orders at RISE.
And with Amber.
Hi, guys. I'm Amber, and I do immigration and family law at RISE.
So let's just jump right in. Feel free to do that hand-raising technological thing to ask questions throughout. We're also going to have time at the end to go through any questions that we're not able to get through as we're going through the slides. So a little bit about us. RISE Law Center is a bilingual nonprofit Wisconsin law office, and we provide direct representation to survivors of sexual and domestic violence. We are part of In Domestic Abuse Wisconsin, and we're also really closely affiliated with the Wisconsin Coalition Against Domestic Violence, and we serve programs from both agencies, dual and individual SA or DV programs. Today, we're going to be having the learning objective of trying to have a better understanding of how immigrant survivors might face additional barriers when they're trying to access justice systems. So just a little bit of background. These are some quick Wisconsin statistics just to get an idea of who is here in Wisconsin that may be an immigrant or be in a blended family. And so in the 2016 census estimates, over 275,000 people living in Wisconsin were born outside of the United States. Of those, over 100,000 were born in Latin America, over 100,000 were born in Asia, over 50,000 were born either in Europe or Canada, and over 10,000 were born in Africa. And of that, more than 500,000 spoke a language other than English in their home. So this could be either a family that is all immigrants or oftentimes a mixed status family where some folks are immigrants and some might be U.S. citizens or green card holders. Some things to consider as we're going through the webinar is just the intersections with somebody's immigration status and violence that they might be receiving in their lives. So there's this fear of deportation if law enforcement ever gets involved in any kinds of violence that are going on in their personal lives. There's also threats or fears of losing children because somebody is quote unquote illegal, undocumented, underdocumented. There can sometimes be threats of being either disgraced or shamed either within their immediate family, within their local community, or maybe even within clan systems. There might not be any family or support network close by that somebody can turn to. And oftentimes people who are underdocumented are dependent on their abuser when they're in these domestic violence or sexual assault type situations. So they could be dependent due to language issues, cultural issues or understandings. They could be dependent because perhaps their abuser is the only person in the family who can work, who legally has the ability to drive, or just has general access to different community resources. So that's a little bit of background to think about as we're going through these, and we're going to jump right in with restraining orders and injunctions.
Okay, so I am just going to do kind of a quick overview of Wisconsin laws, and we're going to try to look at this through the lens of what additional barriers immigrant victims might face when filing restraining orders in Wisconsin. There are 4 major types of restraining orders in Wisconsin. So domestic abuse, harassment, child abuse, and individuals at risk. In my work, I mostly deal with domestic abuse and harassment ones, though I do quite a bit of child abuse ones. And the process for them is fairly similar. So this process that we're going to talk about would encompass any of them. So basically, what do people have to do, right? So they have to complete the petition for the temporary restraining order and the notice for the injunction hearing. They have to be filed with the court. They have to be served on the respondent, and then the hearing will happen within 14 days of filing, with some exceptions. Now, some of the issues that we see with our immigrant clients are where can you find the forms, right? So you can either go to the courthouse and get the forms, or you can find them online. So both of these could create some additional barriers for people who are immigrants. So for example, if somebody is under or undocumented, they don't want to go to the courthouse. They're afraid to just come in because they don't know if somebody's going to ask them about their status and maybe detain them. If people want to find the forms online, sometimes there is an accessibility issue. Do people have computers? If they do, can they actually access and navigate to the website where the forms are? And I don't know how many people actually have tried to do that, but you have to go to the court website, and then you have to find the tab that says forms, and then you have to make sure that you click on the circuit court forms, and then you have to figure out where the restraining order forms are, and all of that is in English. So while the forms themselves for restraining orders are in English, Spanish, and Hmong in the actual website, in order to navigate to where the forms are, if you cannot read English, then it's more difficult to do that. Like I said, the forms are in multiple languages, but every time there is an update to the form, the forms that are not in English are not automatically updated. So for example, when we recently had the PET added as a relief for restraining orders, for domestic abuse restraining orders, it took a little bit for the Spanish and the Hmong forms to actually have that information in them. There's also obviously the fact that there's a lot of people who don't speak English, Spanish, or Hmong, right? So they don't have the same access to the forms. And then there are a lot of people who may speak English, Spanish, right? But for some people, neither one of those is their first language. There's a lot of different countries in Latin America where the main or mother tongue of most people are indigenous languages. And so for them, they may be able to speak Spanish, but they may not be able to read it. The Hmong language, we know that the written form is not something that every Hmong person knows, because that is more of an oral language. So there are some of those additional barriers for people who do not speak English and who may come from different countries. Now, other things that have to happen with the forms. So the forms, when you file them, or when victims file them, they have to be notarized. And so there are, in order to notarize, there's some requirements that people have to meet. So if you have somebody who's undocumented, but they have to show an ID to a notary public, then where are they going to get an ID from, right? If they don't have a passport, or maybe they don't have any ID from their country, or their IDs may be expired, then what proof do they have that they are who they say they are? And then the notaries have, obviously, their requirements, so they have to either know the person, or if not, then they have to ask for their identification. There is also a way in which a third person could come and say to the notary, oh, I know this person, and the notary has to know the person. It's as a credible witness that when they say, oh yeah, I know that this other person is who they say they are. Sounds like we have a question.
It's more a comment from Dory. She just wants to bring up that it does apply to deaf victims as well, because English is not their first language. So it would be taking more time to use ASL to explain the form needed to fill out, so delay in filing and everything like that. Thanks, Dory.
Great. So then, going back then to the notary requirements, of course, sometimes the notaries, they're supposed to at least have an idea what they're notarizing. So is it okay for them to notarize something that it's not in a language that the notary understands? Is it okay for somebody who doesn't speak English to be signing something that is in a language that they don't understand in front of a notary? So there is also that disconnect. And, you know, we don't have a lot of notaries necessarily that speak other languages or can read them either. So, so that creates additional barriers for immigrants.
And I think we've seen that in our office where people have tried to file restraining orders in person in the court, and they've been rejected from the clerk of courts because they couldn't identify who the person was, and therefore couldn't notify or notarize the documents. And so then they've come to our office saying, you know, what do I do? I'm trying to get this order of protection, but I'm unable to due to this barrier due to my immigration status or lack of.
Yes. And, you know, like I said, clerks of courts and court officials are usually not bilingual. So, and there are some counties in which you actually have to meet with the commissioner. I think Milwaukee County still does this. You have to meet with the commissioner when you file, and they go over your petition with you. So if the commissioner doesn't speak English, if you don't bring an interpreter, if they don't have one available, then how do you do that? And then we come to the service of process. So, you know, after you file your restraining order, then you have to take it to the sheriff's office. In Dane County, there's a service worksheet, but it's only in English. And then people have to fill it out with all the information from the respondent so that the sheriff can go and make sure they found the right person. So that's cumbersome for somebody who doesn't speak English. And not every county has it. And then people have to actually go to the sheriff's office to drop this paperwork. So you can imagine if you're an undocumented person and you're basically walking into a police station, and how fearful that makes some people. And if they can't speak English, and they may not be able to explain to the sheriff then what they need in terms of the service. And then, of course, then we have the hearing. And at the hearing, for the most part, people would request an interpreter when they file the paperwork. And then the problems that we have sometimes is the interpreter that shows up for the hearing may not be as proficient or as professional, and people feel uncomfortable. Sometimes there's clients who have said, oh, I don't want a male interpreter, and you're at the whim of whoever the court assigns. Sometimes it ends up that people are waiting for long periods of time because interpreters get double booked, and people don't want to sit around and wait. They're nervous, all of that. I would advocate that even when somebody speaks a good amount of English, if English is not their first language, it's a good idea to have an interpreter because legal terminology is different. And they may not be as familiar with the terminology that is going to be used in court. It would go to the credibility findings. As I'm sure a lot of people on the call know, injunction hearings, you know, a judge would grant your request if they find that you're a credible witness, and if you don't have an interpreter that is really conveying your message, then that could create a problem for you getting your injunction. And then there's a lot of our clients, of course, that they don't have a lot of knowledge about how different the legal system works in the United States, and the only framework that they have is whatever happens in their own country. And, you know, because of that, they are more uncomfortable when they're in court. For example, there's a lot of other places where this type of hearings would be closed. And here, domestic abuse injunction hearings are open to the public. I don't know in other counties, but I know that at least in Dane County, they schedule 5 or 6 for the same time. So people are not used to having to be there and then have all sorts of other people around for the same thing. In some countries, you need an ID to get into a courthouse, and here you don't need that, and so they might be afraid of that. And then there's, of course, you know, a fear of authority figures like judges, and you know, being an immigrant from another country, not being able to speak English well, then that creates more fear in people. And then representation in other countries, you know, sometimes attorneys are actually appointed for these types of hearings, and here that's not always the case. In fact, it's rarely the case for these types of hearings.
Next, we're going to move into family law. So it's going to be similar to the injunctions where we're going to go through, you know, some of the basics of family law, but also go through some topics that are very specific to immigrant and refugee victims. So, Amber, do you want to start us off?
I do. Okay, so on your screen, you'll see the basic family law actions that we typically see. So divorce or annulment, you're ending the marriage, legal marriage, paternity and paternity acknowledgement, establishing legal fatherhood, doing custody placement, support or maintenance actions. So if there's either not a legal marriage and they're just trying to establish financial orders for either supporting a spouse or supporting the kids, or they don't want to end the marriage. So today we're going to be discussing and focusing on divorce. But something to keep in mind is frequently U.S. citizen spouses or permanent resident spouses, so people who have their green cards, will actually file for an annulment instead of for a divorce as an attempt to kind of attack the validity of the marriage as a way to continue to control and abuse that immigrant spouse, because that could potentially affect their ability to receive an immigration benefit in the future or affect the immigration benefit that they already have. So requirements for divorce, you have to be legally married. So this seems like a no-brainer, but there are countries where individuals will enter into traditional marriages or cultural ceremonies, and these could be legal marriages, but they're not always legal marriages. So usually when someone says, I'm married to someone, first of all, you have to look at the language around it, right? Because in Spanish, pareja, for example, could be partner, meaning partner spouse, or partner meaning life partner. So making sure that it actually is a legal marriage before you say, yes, you need a divorce. You also need to have lived in the state for a minimum of 6 months. So be in Wisconsin for 6 months. This could come into play if someone is fleeing another state, or if children are involved, it comes into play for home state related to that. You also have to be in the county where you're filing for a minimum of 30 days. So these are just the basic requirements. For paternity, they're the same requirements as divorce, except there's no legal marriage, and there has to be at least one minor child. So divorce, you could just end the marriage. Paternity, you need at least one minor child. Okay, preparing paperwork. So there are a bunch of different forms, right, that you're going to have to actually do because it's a legal means to end your marriage. So the summons, you're telling someone that you're suing them for divorce. The petition, you're saying what you need, why you need it, and why you think you deserve the divorce or need the divorce. The confidential petition addendum is where you're putting in all that confidential information that the court will need, but that they don't want to make public on CCAP or anything like that. Filing fee, so this will depend on whether or not you're asking for maintenance or spousal support, or if there are any children involved. There also is a fee waiver request that individuals can fill out if they can't afford the filing fee, and then service. So the divorce paperwork needs to be personally served on the respondent. So this can be done one of two ways. Typically in DV situations, we see the use of the sheriff's office, so someone else who is going to actually sign an affidavit saying that they served the respondent, so the person that is on the other side of the divorce, with the paperwork. That's just because a lot of times people don't want to deal with the runaround about whether or not the person will admit that they actually received the paperwork, which is the other version, so an admission of service.
And if I can interject just one thing here, in the confidential petition addendum, you're supposed to disclose your social security numbers, and that sometimes creates a barrier for some of our immigrant clients who do not have social security numbers. And so we tend to get a little creative with that because they could, instead of a social security number, could use the taxpayer's number, or sometimes we leave it blank and then we deal with it later. But it could create and it has created barriers for some people saying, well, if I don't have it, I can't file for divorce.
So where to find forms, kind of like what Gricel was talking about, you can find them online. They are in the court system's website, but the directions are in English, so you need to find the website, find the tab for the circuit court forms, find family, and then from that, find the divorce paperwork itself. Also, like she said, they're only in the 3 languages, English, Spanish, and Hmong, so you could be in a scenario where you don't speak any of those, where you're not actually able to access it online. Or a lot of times at the courthouse, they'll have like court libraries or reference programs where they have pro se worksheets for people to actually use. Or you can get it from the clerk of courts, like they will have the actual documents in person, which again, what Gricel was talking about before and Robin, is that a lot of times people are afraid to even go to the courthouse if they're underdocumented or undocumented, so that also could be a barrier. So while we only talked about the 3 main forms that you needed to start the divorce, there's actually multiple forms that would need to be done in order to complete the process. So you're going to need to be doing your financial disclosure statement. So that would be requiring someone to provide an accurate reflection of how much money they're making, what their assets are, any debts or liabilities. This could cause an issue if, for example, someone is not getting paid regular paychecks or they're being paid in cash, to actually document what their actually earning capacity is to the court. Also, getting the other person to come to court. For example, using an order to show cause motion type, which is a motion where you actually have to wait for the court commissioner to sign and give you a time, so additional time that someone is going to have to be waiting at the courthouse, versus potentially maybe filing a motion would be better because you don't have that extra wait time right there. Discovery requests, so this is a civil way to get information from the other side. It's super important, especially to get financial information, because we see a lot of times that the victims in these cases don't have access to how much money the spouse is making, what's in their 401k, if there's bank accounts, that kind of information. So it's super important, and it's a super important tool, but it's also a very formal tool. So a lot of times people, especially people who are not represented, are not going to understand exactly how to do it, how to respond to them if they do get them, and there's an extremely limited response time. If you guys do come to a full agreement, so both parties have a full agreement, actually drafting that full agreement, how that would actually look, how it needs to look, how it needs to be formatted. At the final divorce stage, so at your final hearing, the actual findings, so what actually happened at the hearing, what the judge is using to actually make his judgment of divorce. Those can be very complicated depending on the facts of the case. The divorce certificate, so it's another worksheet that the parties would actually need to fill out and have the court send to the Wisconsin Vital Records, so making sure that all of that information is correct. And again, like Gricel mentioned before, they do ask for your social security number, so that's another potential barrier. People might not know really what to put in that section. And again, like we've been mentioning, these forms are in English and very limited languages if they are available in limited languages. So again, a barrier in that respect.
We do have a question.
All right. Okay, so the question is, if one of the 2 persons is here in the U.S. and wants to get the divorce, does the person need, do you need the other party to be there in order to get the divorce?
You don't. And in fact, if the other person doesn't live in the state of Wisconsin, even if they live in the United States, they don't necessarily have to appear to any hearings. Your only requirement is that you will have to have them served, whether they're in another state or in a different country. So, and then services per statute, right? It has to be an adult, resident of whatever state or country the person lives in, and they have to go find them and give them the paperwork in their hand. If you cannot get an admission of service, like Amber was talking about earlier. But they do not have to be present. Now, most of our courts allow for people to appear telephonically, and so that's always a possibility for people if they are outside the country or the state, or even within the state but really far away.
One thing to think about, though, when the other party's outside the country, when Gricel was saying the person has to be served, that can get really expensive. Sometimes it could be, you know, a few hundred. Sometimes it might be thousands of dollars, depending on how the service has to be handled within that particular country. So it could be a huge barrier if one party is not in the United States.
And just one last thing, there's also a time limit for service. So you've filed the divorce documents and you have 90 days to serve the other party. That could also be a barrier if the person is outside of the United States. So if you're assisting someone with this type of paperwork and you already know that the other person resides in another country, the first thing you need to be asking is, do you have his address? Do you have somewhere that meets the requirements, or someone there that meets the requirements Gricel was talking about who can actually serve them, so that there's no delay in processing, or worst case scenario, they dismiss the entire action because you can't do it within that time period.
One of the first steps after you file the divorce is you can choose to have a temporary order hearing. Usually, because there's a waiting period from the time the divorce is served to the time the divorce is final, the temporary order will give you some orders and basically rules as to how you're going to conduct yourself, your finances, your children, while the divorce is pending. And so then, you know, how do you decide if you need a temporary order or not? And what do you request in a temporary order? So basically what I tell my clients most of the time is, if you have children, you probably want a temporary order, because then you can have initial orders on custody and placement, but also support and, you know, property division. And for property division, it's mostly, you know, who gets to stay in the apartment that they're renting or the house, what car each of them drives, so minor stuff like that. And then you can request basically anything in a temporary order hearing that you would at a final divorce, right? So like I said, support, maintenance, all those things. However, you do need to file a motion like, or an order to show cause, like Amber was explaining earlier, requesting the hearing and what relief you want. And for victims of abuse, right, it's the first opportunity to deal with issues, like I said, of custody, placement, support, maintenance. Now, for immigrant survivors, one bad thing, I think, that happens during temporary order hearing is that if the other party actually is documented, immigration status may be brought up. If the person may have permanent residency, the victim, but it's a conditional one, the condition is because you're married to this other person and now you're going through a divorce, so that may be brought up. A person's language skills, right? I have had cases in which my clients are denied custodial rights because they don't speak English. And how are they going to make decisions? How are they going to talk to the doctor? How are they going to assist the children with homework and things like that? Or if they don't have status, if they're undocumented, they can't have a driver's license, so then they can drive the children around. Abusers tend to use, obviously, that to get the upper hand. And, of course, as we know, one of the main things abusers use to threaten victims is, I am going to take the children away from you. And when these other things happen, especially for immigrant survivors, it seems to them that that's a reality that could actually happen. For our immigrant survivors, then of course if you want sole legal custody, for example, right, you have to have evidence of the abuse, and your testimony as the victim is a good part of that evidence, but you may also need medical records, police records, and court records. And once again, like we've been saying, if somebody may not speak English, or if they have limited financial resources, they may not be able to obtain, even know how to obtain copies of these records, but they may not be able to afford to get these records, and how they have to navigate the whole web of systems, because it's not just the courts now, we're involving clinics, doctors, and other people in it. One of the things that we see a lot with the immigrant survivors that we represent in court is that at the temporary order hearing, there's travel restrictions around the minor children. I think 95% of our family cases with immigrants, somebody says, oh, he threatened or she threatened to take the children to another country and never bring them back. There may be an order that the passport for the children and for the parties have to be held by a third party, and then the financial support, both child support or maintenance. And this creates uncertainty, especially for our immigrant clients, because we don't know how long a divorce is going to take, if there are restrictions for how long, what happens if I have a family emergency, if I have to leave the country, how do I renew the passports if I don't have access to them and I may not know when they expire, and how do I prove the other person's financial situation if I don't have access to financial information, if I'm not able to get it because of maybe language access or because I can't afford to pay the bank to give me copies of all of that. So once your temporary order hearing happens, then you have a different process that then kicks in per statute, right? Like I said, there's a waiting period. It's 120 days, and it is from time of service. So if you file a divorce and it takes you 2 months because he's in another country, the other party's in another country, then on that day, 2 months later, that's when your 120 days start to run. And it's between service and final hearing. Then during that time, if there's a dispute regarding the children, custody and placement mediation is mandatory. And then there could be financial mediation, but it's also an opportunity to do discovery papers. And then if there's family and placement mediation is not successful, then there could be a court study and a guardian ad litem appointed. Now for our clients, 4 months seems like a long time, especially because in a lot of other countries, there's really no waiting period from the time that you file a divorce to the time you actually get divorced. Mediation for some of our clients is a very foreign concept. They don't really know what it is, how it works. Custody and placement mediation, even when you're represented, your attorney cannot go with you. So it is more scary for people. And of course, we don't know, again, if they provide interpreters during the mediation process. Some counties do, some counties don't. Is that going to be a problem? Is it going to be a problem, again, how proficient that interpreter may be or how professional they may be? And a big issue that we have with interpreters, especially in mediation settings, is with communities that may be smaller. Everybody knows everybody. So the interpreter that shows up may know both parties. And there might be a perception that they may be talking to the community about what happens. And it's difficult to obviously try to even do an agreement. Like Amber said before, if people can agree on their own, you don't really have to go through the process except for the waiting period. But still, that's difficult to do if you're a victim who maybe doesn't speak English and the other person speaks English. So for the temporary order, one of the major implications for immigrant survivors is the legal custody rights, because legal custody is decision-making, right, for major decisions. And when you have been a victim of domestic abuse, a pattern or a serious incident, and you can prove it, then the law says that you're supposed to have sole legal custody. So that gives you, as the victim, the right to make all those decisions without necessarily having to get the authorization from the other parent. And so technically it gives you the right to obtain a passport for the minor children, and it should also give you the right to travel internationally with the children. However, there's other laws that may affect that. And it's very important for our immigrant victims, and I would argue obviously for every victim, that if you have evidence of the abuse, that you bring it forth at the temporary order level, because one of the main things, like I said before, taking the children away, it's one of the major threats for an immigrant victim, taking the children away because you don't have status. And what are you going to do about it? I can get you deported, and then you're going to, you're going to lose the children anyway. Abusers tend to threaten to isolate the children from extended family in other countries. And the unfortunate truth about the international laws that affect international travel with children is that, for the most part, they would require, regardless of who has legal custody rights, they would require both parents' written consent for a child to leave the United States.
So, sorry to interrupt, but would you say then that when you're in court and you're asking for legal custody, is that good enough, or is it a best practice to be very specific in that included within that legal custody is the right for that sole parent to obtain the passport, and included within that legal custody is the right for that sole parent to travel?
So for the passport, it's not going to be a problem, actually. So just having sole legal custody, you don't necessarily need any more specific orders. But you will for your passport if you actually ask for international travel. And for international travel, you should, it's best practice to ask, can I travel internationally with my child or children? Because once there's then an order about how international travel is going to go, then you actually need the order to also say, you parent who has sole legal custody shall have the right to solely, on your own, get a passport for the children. So it is best practice to be more specific, yes.
Okay.
And, this is the international law that mostly affects the travel, the passports. We call it the Hague Convention for short. There's many parts of the Hague Convention, so the one that is relevant here is the Hague Convention on International Parental Adoptions. And basically, it's just a treaty amongst a number of countries, the United States one of them, about how we're going to handle it when one parent decides to take a child to another country and not return them to the United States. There are our neighbors, both Canada and Mexico, are also full signature countries. There are countries that have signed parts of the convention and not part of other parts of it. But whenever there's two countries who are full signature countries, both of those countries require either a court order that is specific, so that's why I'm saying best practice to be specific, or both parent signatures in order for children to travel between the two countries. It also has a section on how to do service of process for Hague-specific cases, but it's also useful to read it sometimes if it's in a country that you don't know how to do service. It will guide you as to how to do that. And it basically outlines the whole process on how to get children back once they've been abducted by a parent to another country. So it's a little different when the children go to a country that is not a signature country of the Hague Convention. But there are other international laws that actually will also apply, and they're similar.
All right.
So physical placement, just a note, a lot of times victims will come to our office, and I'm sure to you all, and say, I want full custody. So obviously, as Gricel's just said, legal custody, the power to make major decisions in your child's life, and what I'm going to talk about, physical placement, are totally different. But many times, individuals mean, I want that power and I want them to be with me most of the time. So that's always something to kind of try to take apart when someone says. So physical placement is how much time children actually spend with each parent. And then how does that schedule actually look? Every family is different, every schedule is different, work schedules are different, school schedules are different, maybe one of the children plays violin. All of those come into factors when you actually are looking at what kind of schedule you want to set up. Immigration-specific issues and issues that we come across dealing with our actual immigrant victims are, like Gricel talked about, school placement with a non-English speaking parent. So whether or not if you don't speak English as your first language or you have limited English proficiency, can actually assist your children with homework. So whether or not the abuser on the other side will say, I need them all during the week because I'm the only one who can help them with them, and it'll affect their school. Another issue that comes up is where the court's going to start from, and also a lot of times people hear, is that there's an automatic 50-50 placement, meaning that automatically both the children are with both parents for the exact amount of time, even if there is violence in the home. And obviously, as Gricel just talked about, that's why it's super important if you're helping your clients or others in the community that they address that domestic violence or other violence at that earliest point of that temporary order hearing, so that the court can evaluate that and use that in their best interest child analysis when they're trying to determine physical placement. The other issue that comes up quite frequently with immigrant survivors is cultural beliefs. For example, in some cultures, children are always supposed to be with the mother, so that might affect placement in that regard. And in others, they're supposed to be split based on the gender of the child should be with that parent. So also could affect placement, because the court is generally not going to want to split children up, especially if they're young children and they've always been together. So just some issues to look for that. So math. So child support is determined by formulas. So child support obviously is what one of the parents or both of the parents is going to be paying in terms of supporting the actual child financially. So these formulas are done based on the amount of placement, generally, that is with each parent. So, typical ones are if one person has primary placement, meaning almost all of the placement, if there's equal placement, so both of them have roughly the same, both parents have roughly the same placement, or if it's some sort of shared placement. If you're like me and you don't really like math so much, obviously all of these formulas are in the statutes, but the Department of Children and Families also have really, really great tools on their websites, including actually, spreadsheets you can put in the actual numbers and it'll spit out what their estimate is for child support. So definitely look into that if you're trying to calculate these things. So maintenance or spousal support, this used to be known as alimony, so you might also hear it described as that, is actually money paid by one spouse to support the other spouse. So where this might come about in immigrant survivors, in a lot of countries, men are always required to support the women and pay for their housing even after the marriage has ended. If that's where the children are living, and most often the children are living with the mother, versus maintenance in Wisconsin, which is a totally different calculation where the court is looking at many different factors to see if maintenance is even appropriate. So a lot of times clients may come in based on their own cultural backgrounds, assuming things about maintenance, and it's super important to set that straight, because it's not guaranteed and it's not actually even that common that the court would order long-term maintenance in that style. So family studies and guardian ad litem. So what Gricel was talking about earlier, there are scenarios, and frequently there are scenarios when there is an abusive spouse and a survivor of abuse, where custody, so legal custody and physical placement, are in dispute. So they are not able to reach an agreement, and now they're kind of at a standstill with their case. At that point, the court is required to actually appoint a guardian ad litem. So a guardian ad litem is the attorney who is appointed by the court to represent the best interests of the children. So it is not the child's attorney. It is someone who is there to investigate and do an analysis so they can do a recommendation to the court as to what they think is in the best interest of the child. They're also required to appoint a guardian ad litem anytime there are allegations of domestic violence in the statutes. So again, another reason why it's extremely important to bring up those violence issues at the earliest point in the hearing so that the court is aware of it and can deal appropriately with it. Another thing that often happens is a family court study. So that is when social workers or other personnel are actually doing a similar investigation to what the guardian ad litem is doing, in that they're trying to also determine the best interests of the children and assist with that custody or placement dispute in order to actually recommend to the court what they think would be in the children's best interest. So although that is what is supposed to happen, obviously there's extreme amount of inconsistency among the counties. For example, Dane County, they have a full family court study program. They'll appoint them, they'll appoint the guardian ad litem, but that's not always the case, especially in rural counties or smaller counties where they might not have the resources. Even in counties where they might have the resources, it's also kind of difficult usually to find social workers or guardian ad litem attorneys who actually have the language skills or the cultural background to assist immigrant survivors, in addition to the DV sensitivities that you would need in order to address these issues. So a final hearing. Gricel was talking a little bit earlier about how there's a minimum of the 120-day waiting period. Obviously, if you guys, or if the two parties they reach a full agreement, then it'll be a short period right after that. Hopefully you can actually schedule the final hearing. If there's not an agreement, then it could drag on longer with all the other processes, be a couple of year case. So there's really two ways that divorces end. If there's a full agreement between the parties, then the hearing will be a stipulated divorce, meaning it's a full agreement and the judge or the court official just has to actually go through the things that they need, the testimony they need, in order to actually give the judgment of divorce. So those are generally pretty straightforward. If there are interpreters, then it takes a little longer, but everyone's in full agreement, so it's just the last aspect, the legal part. If there is not an agreement, then there will be a trial. So in those situations, both sides are able to present what they believe the court should do in order to actually resolve the case. So those are less common because typically individuals do not want to wait until the judge, who doesn't really know them and is only going to see them for a short period of time, have that much power and decide what's best for them and their children and their future lives, basically. So a lot of times people will push for those agreements ahead of time. Where it can become problematic for survivors and pro se litigants in general, and especially immigrant survivors, is presenting your actual documentation and your case at a trial. So you're going to be needing updated documentation, so updated, again, the financial information that we were talking about, the issues related to Social Security and whether or not you have actual paychecks or proving your assets, those types of things. But you're also working with a group of individuals who already is kind of nervous about going to court, afraid to go to court, so now you're asking them to subpoena witnesses and records, so knowing how to not only do those legally, but also feeling comfortable enough to go further into the court process, going to the sheriff, having them serve people, that they know the actual rules of evidence. So attorneys know there's a huge difference between what is happening outside of the courtroom and what you can actually get in on the record. So knowing, what hearsay is, can you actually talk about a conversation that you heard from a third party, whether or not you need that person in the actual hearing with you, whether or not you can bring letters and affidavits signed. So all of those things can cause issues. And then in the actual trial itself, the questioning of witnesses. So what questions you can actually ask people who are on the stand, what you need to ask in order to establish your case. And also in scenarios where the victim may be undocumented or underdocumented, it might also be a scenario where their witnesses who they would need to prove their case also might be in similar situations, so they might be afraid to come to court, and that will affect the case also. So after the final hearing, so you've either had a full agreement, stipulated final hearing, or you've gone to trial and the judge has made his or her decisions in the case. Then what you'll need is a certificate of divorce. So now in Wisconsin, you fill out an actual worksheet that has all of the information on it, and then give it to the clerk of courts. This is, again, what Gricel was talking about earlier, a scenario where you would need a Social Security number for the actual forms in order to turn it into the Wisconsin Vital Records. So working with individuals that you are helping to be creative in terms of what information to provide there. And then the findings of fact, conclusions of law, and judgment of divorce. So these are like your actual final divorce documents. These can be extremely complicated to create, especially if you are pro se or you've limited English proficiency, because you are basically required to write down all the facts that the judge used to make his decisions, then write down all of the different laws that came into play, and also making sure that it's all concise and very pretty so that the court will sign it. So it can be a document, depending on how complicated your case is, that's like 20 pages long, easily. So another barrier to finalizing this process would be just kind of generally the horror of having to sit down for that. Because even as attorneys, trying to recall exactly what happened in that hearing and write it down in a way that the court will be like, yes, that actually did happen, that is correct, it can be really complicated.
And so before we move on from family law into the next topic, which would be immigration, we wanted to touch really briefly on two issues that continue to come up for immigrant victims and immigrants in general, of course, since the change in administration and all the changes to immigration laws, which is people being afraid of being deported because they are under or undocumented, but they have children who either are here, even though they were born in a different country, and they may also be undocumented, or they have United States citizen children, which is what happens if I get deported and my children stay here. And so there are two different processes to handle that, and we're not going to go deep into them, but just so that everybody is aware. So guardianship would be one. There's multiple types of guardianship, so you would need a guardianship for minors. The court process is outlined in Chapter 54 of the Wisconsin statutes. And there are some issues, of course, with immigrants accessing this type of relief, which, again, mirroring some of the stuff that we have already said, guardians ad litem would have to get involved, so they will appoint an attorney for the best interest of the children. It is a court process, so you have to go to court and do this. And of course, if you have already been deported, then how do you do that? And then can you do it before in preparation? But it's not the best process to do that, because actually a guardianship would imply that a parent is unable or unwilling to take care of their children. And I don't think we see a lot of people just going to court and saying, oh yeah, I'll say that, even though what is happening is that I'm afraid to be deported. But you can't really go to court as an immigrant victim and say, I'm just afraid of being deported, so please give me a guardianship, even though I'm still here, right? It could put the court in a really weird position too. And then, of course, there's all the issues like we've mentioned before, the language issues, the forms are only in English for guardianship, and these are closed proceedings usually, so not a lot of other people have sat through them, so it's more difficult to actually find somebody who's not an attorney who would be able to help somebody go through a guardianship process. And so then one of the things that a lot of people have been doing are drafting powers of attorney to delegate parental authority. This is possible. The law is in Chapter 48 of the Wisconsin statutes. And this is a better solution. It's not perfect for a lot of undocumented immigrant parents and victims who actually want to make sure that their children are going to be protected in the event that they're removed from the country. So the best thing about the powers of attorney is that the parent or parents retain control over which decisions they're delegating, so they don't have to delegate every decision. a bad thing about them is that they're only valid for a year, and it's just with some exceptions. There's actually some exceptions also as to what power can be delegated. There are a few decisions that you cannot delegate to another person. So somebody who has power of attorney cannot decide if a child that is under 18 can get married or enroll in the military. You cannot terminate your parental rights via power of attorney. And the person who has power of attorney cannot decide to TPR you, so terminate your parental rights. And a person who has power of attorney cannot decide whether a child who's under 18 can have an abortion. So those four are exceptions. But any other decision can be transferred, but the parents can decide which ones they do. Now, when this becomes more relevant for our immigrant victims is if in the family court process, an immigrant victim ended up with sole legal custody, then they on their own can then delegate their parental authority to another person. If people have joint legal custody, then both parents have to do it. And then they have to delegate it to the same person for it actually to be valid. So it can get a little tricky, but it is a good way to for people to ensure that their children are more protected. And like I said, they have to do it every year. The exception is if the person who you're delegating the authority is actually a relative of the child. So if it's a grandparent, an aunt or uncle, then it could be done for more than a year.
Great. Now we're going to go into immigration remedies for victims of domestic and sexual abuse. We're going to start with just a little bit of background on, immigration status generally, and then we're going to go into two remedies. We're going to talk about VAWA today, and then we're going to talk about the U visa. If we have time, we might mention a couple of other remedies, but we really want to focus on those because those are the most common remedies that we see in our programs that are serving sexual abuse or domestic violence victims. So just a little background or a little idea about how immigration works. There's really a hierarchy of immigration status. The reason that this is really important is because the lower you are on the hierarchy, the more vulnerable you are to abuse. So at the bottom, we have people who are out of status. Sometimes this is called undocumented. It could be somebody who is documented, but maybe their visa expired, and so they're just like underdocumented. It could be somebody who crossed the border with no type of permission. That's often called EWI. It just stands for entering without inspection. So this is somebody who really has no legal status in the United States at the moment. And they're at the bottom of this hierarchical, not really pyramid, but I guess arrow. The next category that we have up are non-resident or non-immigrant. These are temporary statuses. So they're basically the alphabet. There's just a few listed, but you really could just go A, B, C, D. I don't remember where it ends. It doesn't quite go to Z. But it's basically the alphabet of temporary statuses. So it could be something like a B, which is a very common just visitor visa, right? You could have a K, which is a fiancé visa, which you might see a lot when you're working with VAWA. You could have like specialty visas for entertainers, athletes,
Justin Bieber.
You also have different temporary statuses, for example, U and T, which is for U non-immigrants or T non-immigrants. And we're going to go into the U non-immigrant status, but that is also just a temporary status. So it does give people some limited permission to live in the United States and work in the United States. And I should say not all non-immigrant status allows you to work in the United States. But in this, if somebody's in this category, they do have some types of protection immigration-wise. The next step would be really moving up into permanent residency. So once somebody has this sort of temporary status or some type of basis for the permanent resident application, then they may be able to apply for permanent residency. Again, not everybody who has a non-immigrant status would be eligible to, but those who can move up into permanent residency, that's going to give a lot greater protections. And then the best protection really is once somebody becomes a U.S. citizen. With that, you can do anything. So the most common pathways for immigration status, so basically the most common pathways all the way up into citizenship or residency or visas would be family-based. So this is something very typical that people hear about all the time of, oh, I'm applying for my, brother or sister to come to the United States, and they're going to get a green card, and we're all going to live together, and it's going to be great. So this is a family base. It's applying for spouses, children, parents, either of somebody who's a U.S. citizen or a legal permanent resident. And the idea of this is to create more family unity. There's also employment-based, so this could be workers, entertainers, extraordinary immigrants like Justin Bieber, who have skills that are valuable to the U.S. economy. And then there's humanitarian-based, and humanitarian-based is really what we work on within our office. Some examples of it are temporary protective status, refugees and asylees, special immigrant juvenile status, battered spouse and children, which is the VAWA, UNT status, and then DACA. We have a little asterisk next to that because it's no more, but there are still applications processing, and we're always keeping hope that something positive will happen there, even though right now there's no new applications being filed. So the two, like I said, that we're going to go through today are the VAWA Self Petition and the Nonimmigrant Status. One thing to think about with VAWA too, though, is that along with the VAWA Self Petition, VAWA also allows people to remove conditions. This is for somebody who might have a temporary green card based on marriage, the 2-year green card, and they may leave their abusive partner before their green card is up to remove those conditions. So they can actually use the same VAWA language and essentially the same VAWA factors that's found in the VAWA Self Petition to remove those conditions and apply for the permanent 10-year renewable green card. There's also VAWA cancellation of removal. So again, it's using the same factors found in VAWA and the VAWA Self Petition for people who are in removal or deportation proceedings from the United States to terminate that. And then the Nonimmigrant Status is will be the second one that we're going through today. So for the VAWA Self Petition, the first thing to think about is who can apply. Well, people who could apply would be an abused spouse of either a U.S. citizen or a lawful permanent resident, the abused child of a U.S. citizen or lawful permanent resident, the non-abused spouse of a U.S. citizen or lawful permanent resident where their child was abused by that spouse, or the abused parent of an adult U.S. citizen, not legal permanent resident, just U.S. citizen, and that U.S. citizen needs to be over 21 years old to be considered the adult. So the purpose of the VAWA Self Petition is really, it helps to eliminate family-based barriers. When we looked at the slides previously and we talked about the most common ways that people immigrate into the United States, we talked about family-based. So in the family-based petition, the abuser maintains control over the process. What this means is it's really up to that abusive partner, child parent to apply for their family member to be able to get their residency, their work permit. And if that person never applies, then the abused family member can't gain that status. Sometimes the abuser will apply but continue to hold that over the person's head of, well, we're not going to go to the next step, or I'm not going to go to an interview with you, or I can withdraw this at any time if you don't continue to do what I say. So the VAWA Self Petition removes the control from the abusive family member. So it's generally the same requirements as a family-based petition, showing a valid and good faith marriage or relationship, showing residence with the abuser, showing that the abuser is a U.S. citizen or a legal permanent resident, and also showing good moral character. But on top of that, you need to prove abuse for the VAWA Self Petition. Some of the benefits of doing a VAWA Self Petition is there are access to some public benefits almost immediately. This kind of varies state by state. Our state, unfortunately, isn't as VAWA friendly of giving these benefits away as quickly as some other states might. That oftentimes people can apply for their permission to work or receive their permission to work as early as 3 months after filing, And with this permission to work comes somebody's social security number that they can apply for, also comes their driver's license. And oftentimes, not all of the time, but oftentimes people can apply for permanent residency upon VAWA approval. Actually, when this happens, typically you apply for both at the same time. They just won't start working on the permanent residency until the VAWA is approved. So the times when people can do this is if they have no inadmissibilities. So inadmissibilities are typically, but not always, if somebody has major criminal violations or major immigration violations, or if they are married to a lawful permanent resident, then they're not considered immediately eligible for the permanent residency. They have like sort of a date in immigration that you have to check every month, and when your date's up, then you can apply for your residency. It could take years. Another benefit to the survivor here is once a person has the lawful permanent residency, they can apply for their citizenship after 3 years. Some of the limitations are oftentimes the survivor has no or very limited access to really important documents that prove the valid marriage to the U.S. citizen or legal permanent resident. Oftentimes there's limited to no proof of residence with that spouse. There might be different time restrictions on applying. So for example, if somebody's divorced, they need to apply within 2 years of that divorce. If they wait 2 years and 1 day, they're no longer eligible. Also, there's different time and evidence restrictions for adult children. You would need to apply before 21, but some adult children could apply up until 25 if they could prove that they were unable to apply earlier due to the abuse. It also doesn't include situations where either there wasn't an actual valid marriage, maybe it was a cultural marriage that wouldn't be considered a valid marriage in the United States. It doesn't include if somebody really can't prove that they have the good faith or that they live together, or maybe they have some kind of good moral character flaws that wouldn't be overcome with some of the VAWA exceptions, or if the abuser was not a U.S. citizen or lawful permanent resident. In those instances, then we look to see if that person would be eligible to do the U non-immigrant status or the U visa.
Okay, U non-immigrant status, so that's more commonly known as a U visa, so you will more typically hear it as a U visa. So the idea behind it is to help victims of violent crimes here in the U.S. come out of the shadows and be able to feel comfortable to report that victimization to law enforcement, and also to help law enforcement investigate and prosecute those crimes. So who can apply? The first requirement is that you're a victim of a qualifying crime. So here are the lists that USCIS provides for what a qualifying crime is. An important note is that these are guidelines, and so they're not inclusive of all qualifying crimes. Another thing to note about it is that these are based on the federal definitions of these crimes. So in a lot of states, they actually will look different or be called different. So it's really about looking at what the elements are of the actual crime that was committed. For example, in Wisconsin, we don't have a separate domestic violence statute. What they do is add it on as a modifier. So if someone is a victim of, disorderly conduct with a domestic abuse modifier, that would still qualify under domestic violence. So with the U and determining what is a qualifying crime, and with any single immigration thing that could ever happen in life, you should make sure that anyone you're working with, if you think that they do have some sort of immigration issue, that they meet with an attorney to discuss it, because there's a lot of stuff you need to know, and you don't know what you don't know. So other requirements, I already talked about that you have to be a victim of a qualifying crime as they define it. You have to have information about that crime. You have to cooperate with law enforcement in the investigation and prosecution of that crime. And law enforcement here is more generally defined, so that could be the police, that could be cooperating with a prosecutor or a DA's office, that could even be CPS, like child enforcement or child protection services. You have to have suffered substantial mental or physical abuse as a result of the criminal activity. So it's super important that individuals are able to actually tie back the effects to the actual criminal activity that they are saying they were a victim of for this U visa. Substantial mental or physical abuse, It's not super well defined. Usually it's all about the totality of what people are able to put together. We always help people draft declarations to really describe it all. That would be where it would be super important if you're helping someone to gather police reports or other types of evidence that you can use to show the actual abuse. It's super important to give USCIS and the government like kind of your best picture of what the abuse actually looks like. I always say to people when they ask me what they need is that USCIS gets tons of piles of paper, and you really need to make you come out of your application so that they feel you as a person and they feel compelled to help you with this type of relief. You also have to be admissible to the U.S. or eligible for an inadmissibility waiver. So Robin was talking about more about the restrictions related to VAWA. The EU has a much more forgiving inadmissibility waiver. So if you can show that it's in the public interest for you to remain in the United States, then they generally will waive almost every type of inadmissibility you might have to the U.S. So some typical issues that we see that would potentially affect a VAWA or a family-based case would be multiple undocumented entries, so multiple of those EWIs, so there's entries without inspection, or other things that may come up in survivors' scenarios, such as they need to work to live and support their families, so maybe they've used the name of someone that might be someone from here, so something like that. So those types of inadmissibilities can be addressed within the U visa application. In terms of evidence to show it's in the public interest for you to stay here, that would be things like copies of birth certificates of U.S. citizen children. If you're involved in your church or your kid's school or other community activities, letters from people in the community who are attesting to the fact that you are a good person and that you are a benefit to us here, all of us here in the community in the U.S. Important with those letters is obviously those are letters going to the immigration services, so it's important to have individuals who are comfortable giving their contact information and their names and signing for you in this. So usually people use U.S. citizens or lawful permanent residents. Okay. Benefits to the survivor, so the person who's actually applying for this status, is temporary legal status for 4 years, meaning that you would be able to get the U.S. status and remain here for 4 years, work here, and be here legally. The opportunity to apply for family members, so that's generally based on age. So for immigration purposes, a child is defined as anyone under 21. So if the victim is under 21, they could include their parents, their siblings if they're under 18, or their children under 21, or their spouse. If they're over 21, then it's your spouse or your children under 21. There's also scenarios where you could potentially qualify if you were an indirect victim. So we see this a lot if a U.S. citizen child is the victim of a criminal activity in the U.S. and then the parent who may be undocumented or underdocumented is actually able to apply as an indirect victim because they were the ones cooperating with law enforcement. So it is definitely a benefit that can help the entire family potentially in these scenarios. The person is also eligible for work authorization at the approval of their U status, and they can apply for permanent residency, so for their green card after 3 years of being here in that U status, and they can apply for citizenship 5 years after getting that green card. So it is a permanent path. So limitations for the U, the crime has to be investigated, so meaning if you are just a survivor of domestic violence or of another crime, it's not enough to qualify. You'll actually have to had to reach out to law enforcement in some capacity, and there usually has to be some sort of a report or something because the police or the DA's office, they're going to need that information to actually know that you were a victim and to actually tell the government that you were in what is below that as in their certification. So a person applying for a U visa has to actually receive a signed certification that is signed by law enforcement saying, yes, this person was a victim, and yes, they were helpful, and here's the ways they were helpful. This is completely discretionary, meaning that if the police don't believe you were helpful, or they might have a blanket policy against not signing, or it just might be their policy that they only sign in specific circumstances, you could just not be eligible even though you would fulfill all other requirements. This is another issue where it's super important that if you believe someone may qualify for a U visa, that you reach out to an immigration attorney just to make sure that it doesn't create an issue in terms of offending a law enforcement personnel, or making sure that we are able to put in exactly what needs to be in there in order to build a strong U visa case beforehand. The wait time for these decisions are really long. So currently there's a 4-year wait period just for an initial decision. So this is not even for the U visa, this is just for deferred action. So basically getting a letter saying to USCIS, it looks like you will get a U visa, but there aren't any available because there's only 10,000 available a year, and there's about 100,000 people waiting. So if you guys, again, I don't like math, but if you guys do the math, that's about 10-year wait period. So the initial decision is just that, an initial decision. It is not the actual granting of the U visa. But with that initial decision, generally people are eligible to apply for work authorization, and they're added to a wait list, and every year when the government releases more U visas, they would be able to move up that list until it's actually their time to receive the status. And the last limitation is that the survivors have to cooperate with law enforcement, and this can be extremely difficult because they're afraid of the abuser, or they're afraid of law enforcement because the abuser may have said, you know, you're undocumented, so they won't believe you, they'll just remove you. So asking someone to step out of that comfort zone and actually go and cooperate with law enforcement, and that is sustained cooperation, meaning that if you called the police the first time, but now they want additional information, you're continuing to cooperate, can be extremely difficult for individuals. So like Robin said before, there are other immigration options for survivors. I'm just going to touch on them briefly. So a T visa, the T non-immigrant status, is basically the U, but it's for trafficking victims. So if that is coming up in your work, something to think about. Asylum, so someone who's been the victim of past persecution or has a fear of future persecution, if they're returned to their home country and now is asking to stay here permanently in the United States. That's different than a refugee because the asylee is already in the U.S. applying for it, versus a refugee who would be out of the U.S. Special immigrant juvenile status, so that is for kids who are here without a parent or guardian who have either been abandoned and they need to be adjudicated through the family court system and also have this status through immigration. So if you have a client who is a child and you think maybe might qualify for this, it's also super important to reach out to an office like ours that does both family law or immigration, or know a family law attorney who's familiar with this and an immigration attorney who would be familiar with it, because it actually requires both sides to be working kind of together in order to get that done. And then deferred action for childhood arrivals, so that's DACA, that's what Robin was talking about before. This used to be an option. It's no longer a program, but there are still individuals who have DACA status and who have DACA applications pending, so we're hopeful that something more permanent will come out of that. So important questions to ask to help figure out if there are any potential immigration remedies available for your clients or other victims that you're working with. So is your abuser a U.S. citizen or permanent resident? So that would be super important in determining if maybe they potentially could qualify for a VAWA, or if, you know, it's a scenario where they might already have some sort of status. So a lot of times they'll already have that conditional 2-year green card, but the person has said, if you ever leave, I'll just call immigration and take it away right away. That's not true. They can't just call immigration. There is no, that's not a thing. But it's super important because a lot of times people won't realize that they still have that status if they actually report the abuse or they leave the relationship. And then establishing what the actual relationship is to the abuser. So this could come into play for VAWA also if it's a scenario where you were married to an abuser and now you're divorced in terms of that time period that Robin talked about before within that 2 years, or if it's going to be in establishing if it's domestic violence or just another type of assault, because that would also determine that. Have you reported the abuse to law enforcement? So that's super important. And it's also super important when you're asking that question to ask it in a way that could include, you know, did your sister report it to law enforcement and then you talked to them when they came to the house, or if there are other ways that they actually communicated with the police or CPS or the DA's office, for example. Was the abuser arrested? So that also is important to ask, because that'll show to you that it's probably a crime that was investigated after the law enforcement actually came to the house. It's also important because it may potentially mean that there's a criminal case, which would be another potential person who could sign the certification moving forward, like a prosecutor or a district attorney. Have you cooperated or reported to Child Protective Services? So this is another place that you could potentially find a certifier, because, for example, if you've reported to CPS, but they didn't necessarily open a criminal case, if you've reported and you've cooperated with Child Protective Services, that's still you cooperating with law enforcement to help them investigate criminal activity. Have you ever been arrested? So it's really important, because what Robin was talking about with the good moral character for VAWA, and also for the public interest issues under U's, and generally for immigration, that you have a really clear understanding of what the person's criminal history, if there is any, for immigration purposes, because different types of crimes and even non-crimes mean totally different things to immigration that are not completely logical always. Has the person ever been deported from the United States? So deported can be a kind of loaded word, because currently the government calls deportation proceedings removal proceedings, because you're not being deported, you're being removed from the country. And so when you're asking people if they've ever been deported, it's super important to ask, in addition to that, have you ever been stopped at the border? Have you ever had any contact with immigration officials at all? Because that will help to kind of unravel whether or not it was a deportation, whether they were returned. And even if it's something that you yourself don't feel comfortable saying, yes, this is a deportation, yes, this is not, it's still information that whatever attorney you're working with is going to need to know in order to determine whether or not they're actually qualified for any of these benefits. And then the last super important thing is how, where, and when did you enter into the U.S.? This is important for a number of reasons. One, because it could trigger some inadmissibilities if you entered multiple times into the U.S. without a visa or anything. It also is super important because sometimes people will enter with a visa, and that will affect whether or not they need a waiver and all of those other things, but you're going to need to know if they still have the visa, if they remember where they came in, because if they don't have it or they can't quite remember, if you have as much information as you can do a FOIA request, which is the Freedom of Information Act request, FOIA, and you can actually do that to USCIS, which is the immigration agency within the U.S. who is doing all of these affirmative filings to see if they have a copy of anything, if someone has filed or they think their partner might have filed for them in the past. But you can also do that FOIA request to CBP, so that is the Border Patrol agents, to actually see if they have a record of when they came in, what happened, and all of that information, because that'll be super helpful moving forward.
All right, do we have any questions? We have about 5 minutes left, I think.
So I have some just general ones that I know CERT teams have kind of brought up. And one, I think you guys have kind of already talked about some of this, but a more general one, like for sexual assault specific challenges. So, maybe they do or don't have a domestic relationship with their assaulter. I know some of what you touched on, applies to them with the visa, but what are some of the challenges you've seen for that specifically? And which of those immigration policies are the ones that I guess you guys work with the most for victims of sexual assault, if that makes sense?
I think both the VAWA and the U-Visa. I think that, if it's somebody who's not an intimate partner, then it's going to be the U-Visa, because the VAWA is some type of family member that you're tied to, right? But also, oftentimes with the VAWA, there's huge components of sexual assault that people don't realize right away. Sometimes they don't realize it until, you're about to file the application, and then they say, well, I didn't want to do this, this wasn't right, these other things happened, but we were married, and I'm, you know, and then I pull out our power and control wheel again and say, like, look, you know, it's still not okay. And so I would say those two are the most common. Another place that sexual, like, violence comes up is with trafficking, because you can do labor trafficking or you could do sex trafficking. It's a different type of sexual violence than maybe what we typically think of with, like, a VAWA or a U visa, where, you know, it could be a stranger or intimate partner, and that it's sometimes somebody who's an intimate partner but also totally a stranger, because you had no idea what their intent was when they started the trafficking. But I would say the two that we went over are the ones that we see the most common.
And the other question, I think you all did talk about this at the beginning, and I may have missed it, but for the U and T basis, so thinking about trafficking, I couldn't remember if you guys had already mentioned the status of the victim. So I was thinking, and what's been brought up, are undocumented. Are they, I couldn't remember if they were eligible. Is there any protection for them to report these crimes? Are they eligible under the U or T if they don't have any sort of immigration status?
Yes.
Yes, they are. Yes,
yes.
Definitely. And I think the other thing that we also see with sexual assault aspects of these, especially with the U, is that a lot of times people report after, and it could be years after, and they think because it was in the past that then they can't qualify, and that's not true. There might be limitations in terms of signers for certification, like whether or not the individual law enforcement agencies have requirements, but for the U, there's no requirement for, like, the crime to have happened in the last 2 years. So a lot of times people stop themselves before even seeing that they could potentially still be eligible.
And one thing that's hard, whether it's a sexual assault or the domestic violence, but I think particularly with sexual assault because it's so much more personal, is that with both of these people have to write their stories. So oftentimes people are going back and they're really reliving. It needs to be detailed. It needs to be credible. It can't just be, oh, something terrible happened and I cooperated. Please grant me this visa. You have to say what happened, how you cooperated, and how it truly impacted you. And so part of that is not just how it impacted somebody, you know, physically, but also how it impacted somebody emotionally and mentally over time and might still be. So it's something that can be really difficult for people that we're working with. And it's something that we really try to rely heavily on, you know, advocates, social workers, therapists to help as people are reliving some of what they've gone through.
Also to help as corroboration. So, you know, especially if someone's having an extremely difficult time writing their own version, putting it into words, all the stuff that happened, it's also super important for the advocate working with them to have written a story saying, these are all the things that they've said. It's important because it corroborates that story then to immigration, but it's also important because a lot of times if I'm working on a case and I see a declaration that's not particularly detailed, but I have the advocate's one, I know that over the course of the relationship she's disclosed all these other incidents, and then I can ask for additional details related to that. So it helps on both ends, both before sending and then after.
And I think the final thing going with that is I think a lot of the concerns that we hear also are, you know, especially for undocumented, but for any of these more, like, I guess, lower on the hierarchy immigration status, they open themselves up to reporting. If they don't get the U visa, there's the fear of deportation. There's a fear that immigration now knows about them. Is there any sort of protection for them even if they don't get the U visa?
Not necessarily. So we're kind of living in a different world right now. We have a new governing body, or whatever you would call it. But under the prior administration, there were protections for people who were, you know, victims of violence, sexual, domestic, other types of violence. And under this administration, there is a lot of language saying that there is the same protections. However, the actions are really showing that there aren't.
So it's super important, again, just to plug, and it doesn't have to be us. You don't have to come hang out with RISE Law Center, but because of that and the different administration, it's super, super important before anyone files anything with immigration that you have them meet with an immigration attorney. Because the worst thing you can have happen is someone files something that they're not eligible for because they didn't meet with someone or they're using a notario or something else, and then it leads to complications like removal proceedings and other things of that nature.
There might be some instances, though, where there are some types of protections, not really protecting the person should their application be denied, but these types of applications are held super confidential with immigration, and so they're not supposed to be shared with other parts of immigration or referred for like removal or deportation proceedings. But also considering that every time somebody's filing this type of application, they're going to have to go into an immigration office to submit to a background check. So even though they're supposed to be super confidential and even though this information isn't supposed to be shared, it doesn't mean that there aren't those risks when you're going into the same office that ICE is hanging out in, right? Yeah. I think we're at time, so unless there's any other questions, I just want to say thanks to everybody for participating, and I don't know if anybody else has anything to say before we
just wanted to thank you three for such a great presentation, really informative, and I'm glad we've been able to record it so we can access this. And Sarah and I and Dara will be sending out an email for follow-up information. I think, can we send out the slides? I don't know. Okay, so we'll follow up with slides, and if you all have any questions, reach out to any of us. That's it.
Thank you for having us.
Thanks. Bye.